everybody is aware, we're now operating virtually, and we're going to take the closing submissions from the parties, and I'd like to deal with one other point before we formally close the inquiry today. So without wasting any more time, if I can ask the council now to make their closing submission.
So just
Thank you very much, sir. Can I just check you've got my closing firstly?
Mr. Goatley, you wanted to come in. Yeah.
It's just to say that I've not received an offence closing quite yet, so it'd be very handy to have that in front of me. So,
oh, right, I've sent it. Is it to pg@number5.com?
Yeah, that should be it.
It's gone. Let me just send it again.
Okay. Yep, lovely. It's just come through.
Great. Okay.
Okay. If I can come.
Sorry,
if I can confirm before we start, I have got both closing submissions, so I'm set there. What I would ask people to do, as this is the closing submissions, if people are watching on the live stream, if they could mute their microphones and also turn their camera off, they can probably still watch, but I think that would probably help the proceedings. Ms Daly, were you going to say something before you started your closing submission?
No, I just wanted to check that you'd received them, sir.
I probably should have said right at the beginning, but yes, I have. Yes,
good.
Thank you.
Okay, I'll get started then, unless there's anything else from Mr. Goatley.
Brilliant. Thank you. If you could, that would be great. Thanks.
Good. Okay, so by means of introduction, West Northamptonshire and Northampton specifically is supportive of economic growth and appropriate new employment development, and the development plan reflects that. However, the Council wishes to ensure that growth is achieved in a sustainable manner, whereby Northampton's needs are met in such a way as not to adversely impact on its built and natural environmental assets. By reason of its harmful effects on 4 designated heritage assets and the local landscape, the appeal scheme would not deliver the sustainable growth sought by the Council. It is agreed that there's a strong statutory presumption in favour of refusal of the appeal as a consequence of the harm that it would cause to the 2 Grade 2 star listed churches. That presumption is reinforced by the conflict with up-to-date development plan and national policy, and conflict with the development plan when considered as a whole. The presumption in favour of the development plan therefore creates a further statutory presumption against the grant of planning permission in this case. It is acknowledged that there will be public benefits associated with the scheme, but the extent and level of harm and of policy conflict is not offset by those benefits. In terms of the principle of development, there's much common ground between the parties as to the approach to the principle of development. It's agreed that the development plan, through policy S4 of the Joint Core Strategy and policy EC3 of the Northampton Local Plan Part 2 in particular, provides a permissive policy environment for appropriate new employment development, and that there is no development plan constraint on suitable new land coming forward now. It's agreed that under policy S4, development to meet employment needs is only in principle acceptable if it meets the vision, objectives and policies of the Joint Core Strategy. The vision and objectives of the core strategy support strengthening the economy and creating employment opportunities, as well as achieving high quality design, which takes account of local character and heritage, and which seeks to conserve and, where possible, enhance heritage assets and their settings. The Joint Core Strategy does not prioritise one objective over another. In order to comply with S4, there must be compliance with the vision and objectives taken as a whole, not just the employment or economic related aspects of the vision and objectives. Whilst policy EC3 does not specifically require compliance with the vision and objectives of that plan, Chapter 3 of the Local Plan Part 2 provides a similar vision and set of objectives to the Joint Core Strategy, where high quality design should take account of and improve local character and heritage, the economy should be strengthened and diversified, and where heritage assets and their settings should be conserved and, where possible, enhanced. It's agreed that the promotion of employment-related aspects of the vision and objectives in the Local Plan Part 2 is not prioritised over local landscape or heritage. It's further agreed under EC3 that the acceptability of windfall employment development depends on its consistency with other relevant policies in that plan, as well as policies and other development plan documents, i.e. those within the Joint Core Strategy and the Neighbourhood Plan. And second, development is not in principle acceptable as windfall development under EC3 unless it meets all aspects of that policy, which includes whether the site is suitable for employment purposes through an assessment of impacts on the surrounding area in respect of, amongst other matters, the natural environment and heritage assets. With regards to the location of the appeal site close to and in part next to the boundary of land that's safeguarded employment land at Brackmills under policy EC1, in respect of which Mr. Kirby's written evidence implied that some significance attached, he accepted that there is no policy significance attached to land that is located close to but outside of a safeguarded employment area in the development plan. For example, there's no policy support for the development land that is adjacent to pre-existing employment development. There is, however, a general expectation in the Joint Core Strategy that development will be concentrated primarily in and adjoining the principal urban area of Northampton through policy S1, with which the Council accepts that the scheme complies. The Council submits that the principle of development has not been demonstrated to be acceptable in this instance. The appellant has not demonstrated that the scheme would comply with relevant landscape and heritage-related policies of the Local Plan Part 2, Joint Core Strategy and Neighbourhood Development Plan, and the scheme would conflict with the vision and objectives of the Joint Core Strategy. Turning then to the effect of the appeal proposal on the character and appearance of the area with regard to landscape and visual effects. This is not a case where there are methodological disputes between the parties about the approach to landscape and visual impact assessment. The disagreements are straightforward matters of judgment regarding the nature, scale and extent of the adverse effects in landscape and visual terms that would be brought by the appeal proposal, in circumstances in which Mr. Jackson does not suggest that it would deliver any positive landscape or visual effects. The inspector will be in a good position to exercise his own judgment on these matters following the visit to the appeal site and surroundings. With regard to matters of landscape character, Mr. Wadsworth's careful analysis, which the Council commends to the inspector, of the nature of the existing landscape, including by reference to published character assessments, and his views as to the impact of the proposal in landscape character terms, is set out in sections 2 and 3 of his evidence. In short, his view is that the appeal scheme would have a significant adverse effect on the character of the site and the immediate area, and that the mitigation proposed would not reduce this effect over the years. The appellant's LVIA identifies a moderate adverse effect during the initial part of the operational phase, diminishing to a minor moderate adverse effect after 15 years. The scale of the harm and the efficacy of mitigation measures are therefore key matters of disagreement between the parties. There's also disagreement between the parties as to the extent of the immediate area to which the harm would apply. Mr. Wadsworth judged that an approximate distance of 1,200 metres was suitable, which he explained in oral evidence as a distance that one might reasonably still perceive the appeal site within its landscape context. The appellant's LVIA made no attempt to describe the extent of the immediate area, and Mr. Jackson did not wish to be pinned down on this matter, but did state that he considered the immediate area to comprise a few fields beyond the appeal site to the east, but not as far as Little Houghton. The Council recognises that you, sir, will be able to judge for yourself whether Mr. Jackson's cut-off point suitably reflects where one ceases to appreciate the appeal site within its landscape context. With regard to the experience of the site at present, it's agreed that it has a reasonably pleasant character. It's also agreed that its characteristics give it greater association with the fields leading to Little Houghton and the more open and rural landscape to the east, rather than the developed urban edge of Northampton. Although positive reliance was sought to be placed by the appellant's team on the industrialising influence of Brackmills and Lakeside on local landscape character and the experience of the area, it was agreed that industrial development in the local area has been a detracting feature and that the introduction of further urban or industrial development would not be an enhancement to the character of the area. The presence of industrial development does not justify more of the same. In this regard, Mr. Jackson confirmed that the appellant was not promoting the appeal site as an extension to Brackmills, and he agreed that the A428 provides a physical barrier between Brackmills and the appeal site. It was also accepted that the planting between Lakeside and the appeal site provided a separation between those two locations. The appeal proposal will represent the significant encroachment and intrusion of industrial scale built form into an area of landscape characterised not by pre-existing industrial and urban development, but by its openness and visual sensitivity. As Mr. Wadsworth explained, the presence of brack mills, rather than influencing the appeal site to such an extent that further industrial development would be acceptable, in fact serves to accentuate the rural aspects of the appeal site in its Vale landscape context. The appellant's advocate, through questioning of the council's witnesses, sought to suggest that some significance is attached to the fact that the appeal site was a mineral workings which has been restored. However, Mr. Jackson disowned his advocate's attempts in this regard and was clear that the landscape baseline must be taken as it is now and that this is how it should be assessed. As Mr. Wadsworth stated in re-examination, and as you, sir, will have experienced on site, there is no perceptible evidence on the ground that the site was a former gravel extraction site. That fact should not have any influence on the assessment of the impact of the appeal proposal on the landscape character of the site or immediate context. In terms of the approach to published landscape character area assessments in the context of an assessment as to the suitability of a particular site for a specific form of development, two notes of caution are appropriate. First, general assessments of larger land parcels in respect of their landscape value, sensitivity and capacity for development must be approached sensibly and should not be relied upon as determinative of a site's suitability for a particular form of development. This was a matter of common ground between the parties. This was exemplified by the most fine-grained and recent assessment available in respect of the area, which is the 2018 Urban Fringe Study. As Mr. Jackson fairly recognised, it only makes development capacity recommendations in respect of residential development, and it further expressly states that sensitivity and capacity assessment scores may not apply consistently across landscape character areas, and that care should be taken not to interpret the results as a definitive statement of the suitability of a specific site to accommodate a particular type or scale of development. The second note of caution is that key characteristics associated with the landscape character area taken as a whole are not necessarily suitable for or characteristic of a particular site or sub-area within a character area. For example, the suggestion made by the appellant's advocate to Mr. Wadsworth that it would not be uncharacteristic to introduce 20-metre or 10-metre tree belts on the appeal site as mitigation measures, due to the fact that the broad river valley floodplain landscape character type in the county character assessment includes reference to, as well as limited woodland cover, hedgerow trees, although infrequent, being an important feature where they do occur, creating localised, well-treed areas, was rightly rejected by Mr. Wadsworth. What is important for the purposes of this appeal is the character of the immediate context of the appeal site, which you, sir, will have seen does not include well-treed areas, save within the Great Houghton Conservation Area. What is clear from the national, county and urban fringe published character assessments is that the characteristics of the appeal site reflect key characteristics of the wider landscape, and that those characteristics will be lost or significantly eroded if the appeal proposal goes ahead. The three assessments describe an open agricultural landscape with little woodland cover, limited hedgerows, urban influences, and a contrast between those urban influences and a rural feel. The finer grained analyses describe the appeal site very well. For example, the 18C Nen to Dunstan Mill Billing Wharf landscape character area refers to urban and infrastructure elements, but says that despite the influence of these elements, peaceful rural areas still remain, and that surrounding the lakes is a landscape characterised by predominantly medium to large-scale pastoral fields occupied in areas with grazing cattle, often overgrown and gappy hawthorn hedgerows divide the fields. In respect of the 18D Nen Valley to Washlands character area for the fringe study, the undeveloped parts of the floodplain are described as being characterised by the simplicity of the open mixed farming and pastoral landscapes. The appeal site displays these characteristics. The appellant's attempts to conflate references in the assessments to openness with land being undeveloped were not credible. As Mr. Wadsworth explained, the openness described as a characteristic feature in the published assessments and the openness of the appeal site is a consequence of the absence of built development, along with limited vegetation and limited barriers to visibility across the landscape. It's plain from the language used in the assessments that references to openness comprise a visual element as opposed to simply an absence of built development. For example, the broad river valley floodplain, LCT, is described as having very limited tree cover, where a sense of openness therefore prevails within the floodplain. The fringe study refers to hedgerow trees in the broad River Valley floodplain as creating intimate and enclosed areas, in contrast to the generally more open character elsewhere. And again within the same study, but with reference to the finer grained Nen Valley to Washlands area, guidance states that new development should be controlled or encouraged to conserve and enhance the simplicity of the open mixed farming and pastoral landscapes that characterise the undeveloped parts of the floodplain. Openness is there included as an additional characteristic of a landscape described as undeveloped. So references to openness are not confined to the absence of built development. They also involve the absence of heavy vegetation and a visually open landscape. That reflects the sense of openness experienced in relation to the appeal site. In respect of views in particular, the fringe study refers to views within the 18D character area as tending to be shortened along the valley bottom and near to buildings and roads, but importantly that vantage points from the edges of the landscape character area, such as along the A428, give clear views over the shallow valley to Northampton beyond. A review of the area covered by 18D demonstrates that only a small part of the A428 immediately south of the appeal site and somewhat further east, albeit not extending as far as Little Houghton, makes up a boundary edge of the area. This description can therefore only sensibly be taken to be referring to the appeal site. Mr. Jackson's reliance on the character area being said within the assessment to have a fairly enclosed feeling clearly does not apply to the appeal site, even within the terms of the fringe study itself. What is also clear from the character assessments and a visit to the immediate area is that the mitigation proposed by the appellant is entirely uncharacteristic. In addition to the absence of woodland cover already referred to, the proposed mounding, the scale of which is as yet unknown, is not a local landscape feature, and Mr. Jackson accepted that the only example of the use of mounding in the local area as screening was that which is on the south side of Bedford Road and which screens Brackmills. It's also relevant to take account of the fact that the outline design of the scheme and landscape strategy has been constrained by a significant part of the site falling within the SPA buffer. Mr. Jackson agreed that the decision to place the built development on the southern section of the site along Bedford Road was a function of the buffer. He also agreed that the buffer's extension up to Bedford Road on the western edge of the appeal site meant that there would be a break in built development between Lakeside and the scheme buildings, with a section of habitat enhancement zone between the two, where planting would be incapable of exceeding the 5-metre height restriction. A further significant constraint is the inability of the mitigation planting on the northern boundary of the built development, i.e. that which is located within the buffer, to exceed 5 metres in height. Mr. Jackson accepted that if the buffer had not presented such a constraint, he would likely have recommended planting along the northern development edge boundary at the same site as the southern and eastern boundaries. In re-examination, he suggested that the inability to do so would have no material effect on the efficacy of the screening function proposed to be delivered. It is submitted that this is inherently unlikely. It's plain that planting that will never exceed 5 metres in height will not be capable of screening the significantly higher industrial units from a number of public vantage points to the north of the site. The constraints of the SPA have plainly had a significant effect on the features and design of the appeal proposal, and not a positive one. A further constraint that will result in an adverse effect is the need to deliver a new cycleway and footpath along the southern boundary of Bedford Road, which it is agreed will result in some inevitable permanent vegetation loss. The visual effects of the appeal proposal are comprehensively assessed in section 4 of Mr. Wadsworth's evidence. Points of dispute between Mr. Jackson and him relate to the scale of adverse visual effects caused by the appeal proposal on views from Bedford Road and the visual amenity of users of the public rights of way network and accessible land, which it is agreed includes the Hardingstone embankment. The scale of adverse impact is a matter for your judgment, sir. In terms of the acceptability of the adverse impact, the Council submits that it is relevant to take into account the extensive nature of the public rights of way network that surrounds the site and from which the site can be seen, as will have been plain from the site visit and as is demonstrated by the public rights of way plan. All the assessed viewpoints from which the proposed development would be seen from that network would experience a negative effect, and although it is relevant to note that the Ramblers Association were responding to an EIA scoping consultation in respect of a larger development proposal, Their comment that it is difficult to conceive of a more contentious location to site development, and that development would have a considerable impact on recreational use, remains relevant to the appeal proposal. On the final landscape issue, namely the impact that the appeal proposal would have on the separation of Northampton from Great Houghton, the inquiry heard from local residents as to how highly they value that separation and the important role currently played by the appeal site in maintaining it. The importance of the countryside surrounding Great Houghton in providing a valuable separation between the village and the Northampton urban area is also recorded in the supporting text to Policy 6 of the Neighbourhood Plan. As Mr. Jackson accepted, the effect of the appeal proposal would be that only 2 paddocks would separate the appeal development from Great Houghton. He sought to suggest that the gateway to Northampton is currently perceived at the entry sign on Bedford Road, but that does not fairly represent the perceived and actual edge of the urban area, which presently sits at the lakeside roundabout. The development of the appeal proposal would bring that urban edge right up to the junction between Bedford Road and High Street Great Houghton, bringing with it a significant adverse effect on the perception of Great Houghton as a distinct and separate settlement. To conclude on landscape matters, the appeal proposal would result in conflict with Policy BN5, Policy Q1, Policy 6 of the Neighbourhood Plan, and Paragraph 174B of the NPPF. Moving on then to a different topic, and that is the effect of the appeal proposals on the significance of designated heritage assets. It is evident from the twists and turns and ultimate landing point of the appellant's case in respect of heritage matters that its team failed to take the heritage impacts of the proposal seriously. The appellant has been reluctant to acknowledge and face up to the effects of the proposed development. This manifested in a confused and inconsistent approach taken to the assessment of heritage harm. It was particularly surprising, given that it involved 2 heritage professionals from the same consultancy in apparent disagreement over the effects of the proposal. It was also extremely surprising that 2 documents that Mr. Bourne stated that he had fed into, the Statement of Case and the Statement of Common Ground, contained fundamentally different propositions from those contained within his written evidence regarding the nature and extent of heritage harm. A lack of care characterises the appellant's approach. As regards the findings of the heritage assessments undertaken by the appellant, the purported explanation for the change in view, i.e. the new development on the Howden site within Brackmills, taken by Mr. Bourne as compared to Miss Macquarie, was incoherent for 2 reasons. First, it's plain from the Cultural Heritage chapter of the ES that Miss Macquarie did take into account the Howden's consent when considering cumulative impacts of the proposal, but did not consider that it impacted on her view of heritage harm. Second, the more baffling turn of events was the fact that the 2 assets, in respect of which Mr. Bourne found no harm in his written evidence, i.e. the Little Houghton Conservation Area and St Mary's Little Houghton, in purported reliance on the new presence of the Howden's development, in contrast to the less than substantial harm found by Miss Macquarie, failed to account for the fact that the basis of harm found by Miss Macquarie's heritage assessment related to views towards the conservation area and church, where the Brackmills development could not be seen. Fortunately, the inspector has the benefit of clear, consistent and credible evidence from Mr. Partington regarding the significance of the 4 relevant assets, the contribution made by setting, to significance, or the ability to appreciate significance, and the nature and scale of the adverse effects of the proposal. It's remarkable how little challenge was made by the appellant's advocate to his assessment. The principal thrust of cross-examination of Mr. Partington focused on the criteria that he had set out in his heritage impact assessment, intended to provide a useful yardstick regarding the approach to the contribution that a site or feature makes to the significance of an asset and the degree of impact of a development. Despite the appellant's advocate's attempts to cast doubt on the robustness of that yardstick, Mr. Bourne agreed that it was the only set of criteria before user for consideration and that he did not dispute any part of it. He also expressed agreement with Mr. Partington's assessment of the significance of each of the 4 assets. The Council commends Mr. Partington's evidence to user as a fair, evidence-based and robust assessment of where harm occurs and the extent of the harm. Fortunately, also a good deal of helpful common ground has now been established through cross-examination of Mr. Bourne. So on matters of approach, it's agreed that in calibrating harm, assessing where harm sits on the spectrum of less than substantial harm is a matter for the decision maker, and the NPPF doesn't direct the decision maker to adopt any specific approach to identifying harm or gauging its extent. As the PPG explains, in coming to a view as to whether a proposal would cause substantial harm, an important consideration would be whether the adverse impact seriously affects a key element of its special architectural or historic interest. National policy and guidance does not require the impact of a proposal to affect overall significance in order to constitute harm. Less than substantial harm can be present where an adverse impact affects a key element of significance and not overall significance. National policy and guidance does not recognise negligible as a category of harm. It's only substantial or less than substantial. In accordance with the High Court's judgment in James Hall, harm that is considered to be negligible falls within the less than substantial category and attracts weight. And in accordance with GPA 3, cumulative impact is a matter that USER will need to consider, and where the significance of a heritage asset has in the past been compromised by unsympathetic development, consideration still needs to be given as to whether additional change will further detract from or can enhance the significance of the asset. Dealing then with Great Houghton Conservation Area, Mr. Partington assesses the impact on the Great Houghton Conservation Area at paras 4.23 to 4.30 of his proof, as supplemented by his oral evidence. His evidence shows that there would be less than substantial harm to the conservation area at the middle end of the range. His assessment of the harm that would be caused, the ability to appreciate the significance of the conservation area within its setting, focuses on 4 factors, namely the significant erosion of a core part of the conservation area's significance as a village detached from Northampton, the erosion of valued views of the conservation area from the northwest, the erosion of views of the 2 Houghton villages in tandem, and the further cumulative erosion of valued views of the conservation area from the north and east when seen in conjunction with the Brackmills estate. Whilst Mr. Bourne agreed that less than substantial harm would be caused to the conservation area, he considered it only to be low, less than substantial harm. His written evidence based the finding of low, less than substantial harm solely on a change to oblique views of the conservation area from the north and northeast from Hardingstone Dyke. However, through his cross-examination, it was established that 1, the conservation area is not solely seen in conjunction with the appeal site in oblique views. 2, due to the topography and tree cover, it was common ground between him and Mr. Partington that views of the conservation area within its wider landscape setting were limited to those observed from the north and east, which emphasised the contribution that they make to the experience of the area within its landscape setting. 3, harm to significance arising from the appeal proposal is not limited to views. It also arises by virtue of the impact on the detachment and separation of the conservation area from Northampton, which is recognised in the appraisal as making a major contribution to the setting and character and appearance of the conservation area. 4, Mr. Bourne doesn't disagree with anything said in the conservation area appraisal. 5, Brackmills as an industrial development in the setting of the conservation area has caused harm to its significance, and cumulative harm would arise from the appeal development seen in conjunction with Brackmills. And 6, although Mr. Bourne didn't go so far as to accept that harm to significance would be caused by the erosion of views of the 2 Houghton villages in tandem, he acknowledged that the villages have a historic connection and were probably always physically separate. With these concessions in mind, Mr. Bourne agrees with 3 of Mr. Partington's 4 key impacts, and the 4th, the impact on views of the 2 villages in tandem, is not one that Mr. Partington considered to be particularly notable himself. Mr. Bourne's calibration of harm at the low end of less than substantial is simply not credible. Turning then to St Mary's Great Houghton, Mr. Partington assesses the impact on St Mary's in his proof, paras 4.64 to 69, as supplemented in his evidence in chief. His evidence explains why there will be less than substantial harm to this listed building at the middle end of the range, specifically due to the loss or erosion of valued views of the church from the northwest, and the erosion of valued views from the north and east, and the cumulative impact with the Brackmills estate, and the loss of prominence enjoyed by the church in its landscape setting that would arise. Following cross-examination, it's now agreed that less than substantial harm would be caused to the church on the basis that the appeal proposal would detract from views of the church from within its landscape setting. The existence of harm as common ground is helpful, but Mr. Bourne has underestimated the level of that harm by identifying it as low. His calibration of harm is unreliable, as illustrated by the following points. First, in oral evidence, he sought to position the identification of the church in the conservation area appraisal as a defining landmark of the village, as a description of the church's prominence solely within the village itself, rather than also within the wider landscape setting. This is undermined by the statement in his written evidence that the church spire acts as a visual marker for the village and the wider conservation area designation. Its prominence is plainly not limited to within the village itself. Second, the contribution that views of the church makes to its significance, which he accepted in cross-examination was a positive contribution, was said in his written evidence to be relatively low-key on the basis that only the top of the spire can be glimpsed from a limited number of vantage points. As Mr. Partington explained, both the peristyle and the spire are visible from a number of vantage points within the wider setting and in conjunction with the site, and so Mr. Bourne's assessment does not withstand scrutiny. And third, it's difficult to see logically how a concession that there's a cumulative harmful impact arising from the view of the conservation area in conjunction with Brackmills and the appeal development should not also apply to views of St Mary's Church. Again, although it's plainly a matter for you, sir, to judge the level of harm, it's submitted that Mr. Bourne's analysis is not credible. Dealing finally with the Little Houghton Conservation Area and St Mary's Little Houghton, and I've set out at paragraph 39 where Mr. Partington assesses the impact on those assets within his written evidence. Following cross-examination, it's now common ground that harm would arise in respect of both of these assets at the lower end of the less than substantial harm scale. The nature of the harm in respect of St Mary's is agreed, i.e. it arises as a consequence of the appeal proposal's reduction of or detraction from views of the church, both from Bedford Road and other locations to the west. However, Mr. Bourne's acceptance of harm in respect of the conservation area is limited to views of the conservation area from the west, whereas Mr. Partington's assessment is that harm would also arise as a result of the erosion of views of the two Houghton villages in tandem, and the cumulative impact on the character of valued views looking out to the west from the conservation area as a consequence of the Brackmills estate seen in conjunction with the proposal. The following was established in cross-examination of Mr. Bourne in respect of the conservation area. First, the conservation area appraisal establishes that views out from the conservation area over the open fields and down to the River Nen are a defining characteristic, and the views from the west of Bedford Road, looking over the valley are particularly important for the character of Little Houghton. Second, it's agreed between Mr. Bourne and Mr. Partington that views of and from the conservation area within its rural landscape setting are largely limited to its western side, emphasising the contribution that they make to the experience of the conservation area within its setting. And third, Brackmills, including the new Howdens development, at a distance of nearly 2 kilometres away from the conservation area, is a prominent, large, modern white structure on the skyline seen from the conservation area. Having regard to the agreed importance of the views from the west to the character of the conservation area and the contribution they make to the experience of the conservation area within its setting, along with the acceptance that Brackmills is viewed as a prominent industrial structure, Mr. Partington's view that Brackmills results in harm to the ability to appreciate the significance of the conservation area, and that the significantly closer, albeit lower, industrial appeal proposal development would cause an element of cumulative harm to significance, is coherent, logical, and should be preferred to Mr. Bourne's view. Dealing then with policy conflict, in a context in which there's now common ground as to the presence of harm to all 4 designated heritage assets, it's self-evident, and Mr. Kirby accepted in cross-examination, that for those development plan heritage policies that do not include a requirement to balance public benefits against harm, the appeal proposal gives rise to a policy conflict. The appellant's late in the day argument that development plan heritage policies that do not include a requirement to balance heritage harm against public benefits are inconsistent with paragraph 202 of the NPPF and in conflict with policy ENV6 was a bad one. This argument did not feature in the planning statement or the appellant's statement of case, as accepted by Mr. Kirby. Mr. Goatley suggested to Ms. Ford that her view that there was no such conflict or inconsistency was palpably illogical, yet the argument presented by the appellant's advocate as obvious and logical had plainly not occurred to the appellant's team until a very late stage in proceedings. This alone rather suggests that the argument is not a sound one. It was also run by Mr. Kirby on an entirely incoherent basis. A positive assertion was made that the policies of the Neighbourhood Development Plan and BN5 of the Joint Core Strategy were inconsistent with the NPPF and in conflict with ENB6, but he'd not made the same argument in writing in respect of Policy S10 of the Joint Core Strategy, or notably Policy Q1 of the Local Plan. And in cross-examination, he declined to accept that the argument must logically extend to Policy Q1, seemingly reluctant to suggest that the recently adopted Local Plan Part 2 was flawed in its approach to heritage policy. The argument that policies that do not include a Para 202 NPPF balance are inconsistent with the NPPF or in conflict with another development plan policy is an argument that runs contrary to judgments made as to the soundness of development plan documents by the Joint Core Strategy Inspector, the Local Plan Part 2 inspectors, and the Council when undertaking a review of the Joint Core Strategy. Although not determinative of the soundness of the argument, the appellant's status as the outlier on this issue does cast significant doubt on his wisdom. The reality is that there is no conflict at all between the policies that do not include a heritage balance and the NPPF or ENB6. As Mr. Kirby accepted in cross-examination, none of the relevant policies say that development will be refused if it does not, for example, sustain and enhance heritage assets, and none say that a balancing exercise should not be carried out. The policies do not preclude the carrying out of a balancing exercise. That does not result in an inconsistency with the NPPF or any conflict, and the appellant is simply wrong to suggest otherwise. There is no inconsistency with the NPPF, and Section 38(5) of the 1990 Act does not apply. In terms of conclusions on heritage matters, when the adverse effects on heritage assets are considered as a whole, their collective weight must be significant. The effects in respect of the two Grade 2 star listed buildings, which are assets of the highest significance in accordance with paragraph 200 of the NPPF, give rise to a strong statutory presumption in favour of dismissing the appeal, and the impact on all four assets gives rise to direct conflict with development plan policies. The Council maintains that policies HE1, 5 and 6 of the South Northants Local Plan are also relevant for the Inspector to take into account as material considerations, given that they seek to protect the Little Houghton assets that would be adversely impacted by the proposal. The fact that neither party has pointed to examples of other cases where policies of a different local authority area have been taken into account as a material consideration doesn't demonstrate that the approach is wrong. The appellant has naturally sought to play down the impact of the significant and wide-ranging concessions made by Mr. Board in his oral evidence, and in re-examination he asserted that his calibration was only out by a small margin. However, he'd already conceded in cross-examination that there's a fundamental difference between an assessment of no heritage harm and an assessment of less than substantial harm, having regard to the policy and statutory triggers and presumptions that come into play when heritage harm is found. And as has been explained, the level of harm that he accepted still does not fairly and robustly reflect the harm that would be caused. Best and most versatile agricultural land. It's agreed that the permanent loss of BMV across part of the site is a material consideration to which negative weight should be attributed. Mr. Kirby judges that moderate weight should attach to this harm, whereas Ms. Ford considers that it attracts limited weight. Principal disagreement between the parties on BMV is whether the loss also gives rise to a development plan policy conflict in respect of R2 in the Joint Core Strategy. Mr. Kirby's suggestion that R2 is not relevant doesn't stand up to scrutiny. It's another of the last-minute arguments raised after the statement of case. His argument centres on the idea that policy R2, in referring to the rural economy, cannot be relevant to a development proposal focused on contributing towards Northampton's needs. However, there's no reason why the appeal proposal would not make a positive contribution to the economy of both Northampton and the wider West Northamptonshire area, both of which include rural areas. Moreover, the spatial application of policy R2 is crystal clear in the Joint Core Strategy. It applies unconditionally to development within the Northampton related development area. There's no carve out for employment development within that area. Benefits, and dealing first with economic benefits, so jobs, GVA and employment land. On jobs, the sole employment related development plan target is the minimum jobs target in policy S7 of the Joint Core Strategy. The 28,500 net additional jobs by 2029 target has, according to the latest ONS data, not yet been met, but it's agreed that the Council is on track to do so. Ms Ford explained that significant positive weight should be afforded to the contribution the appeal scheme would make towards the provision of new jobs in the light of the fact that the development plan minimum target has not yet been met. As for Mr Kirby's view that an enhanced level of weight, substantial, should be applied, this was both inconsistent with the weight afforded by his colleague Mr Robinson, but was also unjustified. There's nothing exceptional about the appeal proposal that would justify that enhanced level of weight. On capital spending and GVA, it's agreed that the generation of expenditure within the local economy is a benefit of the appeal scheme. The weight to be attributed to that benefit is not agreed. Mr Robinson judged that significant weight should be accorded, whereas Mr Kirby put it higher at substantial. Neither is justified. As Ms Ford explained, the ES population chapter, drafted by Mr Kirby and Mr Robinson's colleagues at Lichfields, treated the economic output of the appeal proposal, judged on the basis of Northampton and West Northamptonshire, as insignificant, categorising the impact as minor beneficial. Further, she considered it appropriate to compare the level of GVA generated by the scheme with the annual GVA for West Northamptonshire as a whole, which in 2018 was £11.5 billion. That comparison led to Ms Ford's conclusion that the contribution, although positive, was relatively modest, and it's therefore appropriate to only attribute moderate positive weight in the balance. Mr Robinson was honest in acknowledging that he'd not read the ES chapter before drafting his evidence. Mr Kirby said that he had, but despite this, he made no reference to it in his written evidence, and in particular expressed no disagreement with it or sought to justify a substantial level of weight having regard to its findings. Attempts by the appellant's team to distance themselves from the findings of one of their own application documents should be given short shrift. On the basis of the appellant's own ES analysis, the expenditure in the local economy arising from the appeal scheme is fairly judged as moderate and very far from significant or substantial. On employment land, there's no dispute between the parties that there is a continuing need for the delivery of employment land within the Northampton and wider West Northants area, and that there's demand for industrial development of the size proposed in this appeal. However, Mr Kirby's assessment that the positive weight to be attributed to the provision of additional land should be substantial, and Mr Robinson's view that it should be significant, overstates the importance of the delivery of additional employment land. Ms Ford's assessment that moderate weight is appropriate is a fair one. The appellant overstates the weight to be afforded to the delivery of additional employment land having regard to the following matters. First, there's no adopted development plan policy seeking the delivery of a particular quantum of employment floor space, either generally or with specific regard to the use classes that would be delivered by this scheme. Second, there's conversely no constraint imposed on the delivery of additional employment land by the development plan, and there's no need for suitable sites to await allocation in the upcoming West Northants local plan in order to come forward due to the permissive policy environment. Third, Mr Kirby was incorrect to suggest that there's any tension between the delay to the progression of the West Northants joint local plan and paragraph 22 of the MPPF, which requires strategic policies to look ahead over a minimum 15-year period from adoption to anticipate and respond to long-term requirements. It's agreed that the Joint Core Strategy, adopted in 2014, looks ahead over a 15-year period in accordance with the MPPF, and that period has more than 5 years left to run. Fourth, although the Council has not produced employment land need evidence for the purposes of this appeal, having regard to the fact that its updated HINA is still being drafted, the assessment made of the need assessed by Mr Robinson and its influence on the appeal must be put in context. As Mr Kirby accepted, it is relevant for you, sir, to take account of the fact that the assessment of need that he's undertaken, as with the 2021 HINA, looks over a 30-year timeline. It's not an identification of the level of need for this year or even for 10 years, but for a much longer period. It's also relevant in this regard to note that the 2021 Strategic Land Availability Assessment, prepared to support the emerging local plan, identifies a substantial amount of developable and deliverable land that could meet strategic employment needs through the emerging plan process. Next, Mr. Drummond fairly explained that the levels of demand being experienced in the Northampton area for industrial land are not out of step with the national picture, and neither are the significant industrial rent increases experienced in recent years. There's therefore nothing significant or unusual about the general demand for industrial land in the Northampton area that would take it out of the ordinary. Although Mr. Drummond placed particular emphasis on the attractiveness of the appeal proposal to current Brackmills occupiers, only 2 such occupiers submitted letters of support for the scheme, and on the basis of the illustrative site layout, the appeal proposal would be incapable of meeting the express space requirements of either, and certainly not both. Finally, the appeal scheme would not meet levels of demand now, and Mr. Kirby was unable to explain the intended delivery timescales for the scheme should permission be granted. What is clear is that the construction period will take 2 years, as this is the basis upon which the construction period capital spending is analysed. There's also a reserved matters application to be made and determined, as well as the discharge of conditions. All of this will take time. Dealing with other benefits, Ms. Ford accepted that the construction funding and training scheme secured through the 106 could be characterised as a public benefit. It's agreed that moderate weight should be accorded to the fact that biodiversity net gain would be delivered by the proposal, albeit the specific percentage gain would only be known at reserved matters stage. Further, it's agreed that the off-site highway improvements would deliver a public benefit on the basis that the cycle-pedestrian route on the southern side of Bedford Road could be used by local residents as well as those working on the appeal site. Mr. Kirby's judgment that moderate weight should be attached to this benefit puts it too high, as the cycle route extends only a modest distance to the junction of Bedford Road with High Street, Great Houghton. Ms. Ford's assessment of limited weight is appropriate. Whether the public benefits outweigh the harm within the heritage balance. The public benefits do not outweigh the significant harm to the heritage assets. Ms. Ford explained the basis for her assessment of the harm as significant, as relying in part on the number of assets affected, but also on the fact that 2 Grade 2 star listed buildings are adversely impacted, having regard to paragraph 199 NPPF, which establishes that great weight should be accorded to the conservation of designated heritage assets, where the more important the asset, the greater the weight should be. Her approach appropriately reflects the Section 66 statutory duty applicable to the 2 churches, the considerable importance and weight that must be attributed to harm to the 2 churches, the great weight that must be accorded to the conservation of all 4 assets, and the strong presumption against the grant of planning permission where harm to listed buildings is identified. Mr. Kirby's written evidence did not explain the weight that he attributed to the less than substantial harm identified at that point in relation to the Great Houghton Conservation Area. Having regard to the concessions made by Mr. Bourne, he submitted a proof addendum which judged the harm to the 4 assets as attracting negligible weight. This was a conspicuous understatement, having regard to the nature and extent of the harm identified, and further reflected the appellant's general reluctance to take heritage matters seriously in this appeal. Moreover, its credibility is called into serious question when one compares the weight that Mr. Kirby attributed to the loss of BMV, moderate, with the weight that he has afforded to harm to designated heritage assets. Whether the appeal proposal is in accordance with the development plan taken as a whole. It's clear from the development plan in general, and the policies that are supportive of windfall employment development in particular, that development that is appropriate to its landscape context and respect for and the conservation and enhancement of heritage assets are essential component parts of delivering Northampton and West Northamptonshire's vision and objectives, and should be achieved alongside and in concert with the delivery of economic objectives. Whereas here, a proposal gives rise to significant harm in relation to heritage and landscape matters and conflicts with a number of different development plan policies, the principle of development is not supported and the sustainable development strategy adopted by the development plan is not met. In this context, the appeal proposal is not in accordance with the development plan as a whole. In terms of the overall plan balance, in accordance with section 38.6, the appeal must be determined in accordance with the development plan unless material considerations indicate otherwise. In this case, the scheme is in conflict with the plan as a whole. In accordance with the statutory presumption in favour of the development plan, Permission should not therefore be granted unless other material considerations indicate otherwise. The presumption in favour of refusal arising from the development plan is supported in this case by the strong statutory presumption in favour of refusal that arises because of the harm caused to designated heritage assets. None of the other material considerations in this case would justify the grant of permission. There are benefits of the scheme, but the collective weight that they attract is not capable of tipping the balance in favour of granting permission. And to conclude, for the reasons summarised, the appeal should be dismissed and planning permission refused for the scheme. Sir, unless I can assist further, those are my closing submissions. Are you on mute, sir?
Thank you. Yes, no, I have no further matters that I need any assistance on, certainly from the council. Can we now move on then to the appellant's closing, and that's Mr. Goatley. Thank you. But he's also on mute.
Yep. Very unusual in my case, but there we are. So, yes, I'm going to move to my closings. Before I deal with my written closings, can I make some observations, please, in respect to my learned friends' closings? And I will do that by reference to the paragraph numbers in those closing submissions. So if you'd have those before you. The first and an overarching point, if I may, is that the assessment made by the council now is noted to be materially at variance with that which was adopted by the council's officers who considered this matter and recommended it for approval. So the series of criticisms, many forensic, some substantive, might usefully be considered, I would respectfully submit, in that light. I'm not going to pick up clearly all matters with which issue is taken, but if I can highlight the following. The first is at paragraph 16 of my learned friend's closing regarding the landscape characteristics of the area, and that the landscape characteristics set out in the various landscape character assessments are not necessarily suitable for considering the characteristic of a particular site or sub-area. So you were taken through the landscape characteristics, and I don't propose to reiterate that here, but there was a concatenation of such landscape character assessments which went through the grading from the national character assessment areas down to the very much more local. It was a matter that was the subject of evidence, and I'll come to in my own closing shortly, but there was an attempt by my learned friend to read down in those character assessments in order to say, yes, I know what they say, but that's not characteristic. Well, if it's not characteristic, then it's rather difficult to say what is intended to be the utility of those character assessments. Mr. Jackson has set out what the utility of them is, and does it provide a good way of being able to understand the landscape character baseline? With respect, we submit it does, and when one comes to an approach seeking to read down those assessments, that, with respect, should be rejected. If I can turn next to paragraph 28. It's a point in paragraph 28 that is reiterated elsewhere, that somehow there was an approach on the appellant's team where the appellant failed to take the heritage impacts seriously. We would invite you to reject that particular contention. There may be a difference of judgments, there may be differences of assessment, but there is nothing within the appellant's approach or its professional team that indicates any absence of seriousness, nor indeed the omission of any particular landscape, any particular heritage asset for the purposes of assessment. There is a difference of approach. That is not to say there's a lack of care or a lack of seriousness. As to paragraph 29 and the chapter of the ES of the taking into account the Howden's consent, it is quite correct that that is referenced there, but that was referenced there as a planning permission with plans. It was not by reference to that which has been built, and you received evidence in respect of that, that gives rise to a materially different opportunity to form a proper assessment as to the consequence of that Howden's building. And sir, you've had the opportunity to carry out your own site inspection in order to assess and understand what the differences are in that regard. So if I can next take you to the policy conflict issue, paragraph 45 of Malone Friends closing submissions. This is the balance point within national policy, within the NPPF, and the inconsistency. You're invited in a series of paragraphs to look forensically, and I pay tribute to Leonard Friend's skill in terms of her forensic assessment. But what does not arise from those paragraphs 44 through to 48 is any real basis to indicate why the absence of a balance within the policies which are considered in question, particularly BN5, why that is not a feature that gives rise to inconsistency for the purposes of understanding the approach within the NPPF. That is not a bad argument to make on the part of the appellant. Far from it. So it properly highlights to you and invites you to note that inconsistency. And with respect, the suggestion in paragraph 48 that the absence of a balance point means that the policies do not preclude such a balance being carried out does offence to the policies within the development plan that do not require such. In short, if a decision taker operating the policy within the development plan, particularly BN5, was to not carry out a balance, that would not be itself in conflict with that policy approach. But that policy approach would be in conflict not only with the NPPF, but also ENV6. That is an inconsistency, and that is the reason why the provisions relating to section 38.5, as well as the NPPF and 38.5 of the Planning Act, are of relevance. And with respect, that is a particular series of propositions for which no forensic gymnastics with respect give rise to any escape as to its logical consequences. So a short point in respect of BMV is paragraph 54 of Malone Friends closing, and this relates to policy R2. It is suggested that there's no reason why the appeal proposal would not make a positive contribution to the economy of Northampton and the wider West Northamptonshire area within a rural context. That there is, with respect, no evidence of that, or to displace the very positive weight relating to the economic benefits of the development. If I can go to the capital spending and GVA point within paragraph 56 of Malone Friends closing. Malone Friend is quite right, as she was fully entitled within her questioning to highlight the ES chapter relating to population. That indicated that looking at the extent of the positive economic attributes of the site when compared to the overall economy for West Northamptonshire, with an annual GVA of 11.5 billion, then the position is proportionately, inevitably, and inexorably modest. Well, with respect, that's not the salient question for your judgment now, nor for that matter, the judgment that either Mr. Kirby or for that matter Mr. Robinson invited you to consider, which is what is the nature of that economic benefit that arises in this instance. And that economic benefit, among other things, comes to be considered in context of paragraph 81 of the NPPF and the significant weight that should be placed on the need to support economic growth and productivity, and not simply by reference to the quite properly identified ES assessment by reference to the overall economy within the local area. That was suggested as being an instance of the appellant's team seeking to distance themselves from the findings of that ES. With respect, I would invite you to reject that. There was no distancing. It is simply that the exercise of the attribution of weight in the planning balance at this stage is one that comes to be carried out at this stage and is not constrained by the difference in approach for ES purposes, which inevitably has a different context and a different consequence. Now, slightly glossed over at, this is on page 23 and paragraph 59, subparagraph 4, is the council having produced absolutely no contrary employment land need evidence in context of the evidence produced by Mr. Robinson and Mr. Drummond. And what is sought to be asserted is that this is some form of just long-term exercise which has no regard to the identified deficiencies in the council's own 2021 HENA, or indeed the shortfall in land arising under the current development plan, and most specifically presently and going forward. That is why Mr. Robinson's and Mr. Drummond's evidence is so critical and key, and why it demonstrates the failure on the part of the council at this inquiry to truly grapple with the nature of the employment shortfall that it is currently facing, and what the current difficulties are that need to be met. It's suggested in paragraph subparagraph 6 that, well, this is really the same as anywhere else in the country. Well, the point is, the need is here. The need is here in Northampton, and there is no contest to Mr. Drummond's evidence that that need exists and where it is located. In subparagraph 7, about only 2 Brackmills occupiers, well, you do have those 2 occupiers, and I'll invite you to look at Mr. Drummond's appendices in that regard. But the suggestion is made that the appeal proposal would be incapable of meeting the express space requirements of either, and certainly not both. With respect, that is contrary to Mr. Drummond's evidence, and it's on the basis that the current outline layout is just that, in outline, and for the reasons he explained, it would be entirely possible for that outline to change in due course. Whether it is possible to accommodate more than one of them, that obviously is a matter downstream. As to subparagraph 8, that essentially this